Good morning, everyone. Welcome to the latest episode of PYA's Healthcare Regulatory Roundup webinar series. Today's topic is No Surprises Act Update. PYA is happy to present today's webinar on this important topic. You may submit questions during the webinar by typing a message into the questions pane of the control panel. Also, immediately following the end of the webinar, you will be asked to complete a short survey and submit any additional questions. We will respond to questions posed after the webinar via email. We have posted in the handouts pane of the control panel a PDF copy of the slides for your reference. Also, you will receive an email later today with a copy of the slides and a recording of the webinar. With that, I would like to introduce our presenters, Martie Ross and Kathy Reep.
Thank you, Trevor. Good morning, everyone. Thank you for joining us. You probably registered for a webinar called No Surprises Act, New Proposed Rules. And you just noticed Trevor referred to this webinar now as No Surprises Act Update. And here's why. Back in August, posted to the Office of Management and Budget's website listing regulatory actions under review, there were two proposed rules relating to the No Surprises Act. One referred to the Federal Independent Dispute Resolution Process fees. The second was IDR operations. And we anticipated that both rules would have been released by the end of October. What in fact has happened is that one of those two rules, the one concerning the administrative fee and the cider fee, has been published. And in fact, the comment period on that proposed rule closes tomorrow. And we will go into that proposed rule in depth today. The second of the rules that had been sitting at OMB under regulatory review, the one on IDR operations, yesterday moved off the list. So Kathy and I are the neurotic people that check the OMB regulatory update on how often, Kathy? 2-3 times a day, probably?
Absolutely.
And I get an all caps email message from Kathy yesterday. Operations is off at OMB. And so we anticipated that the rule would be released yesterday or this morning. There are always three bites of the apple.
We felt spiteful enough to release it this morning at about 9 o'clock, but.
But each day there's three bites of the apple. The public inspection for Federal Register is updated at 8:45, 11:15, and 4:15 Eastern each day. And that gave us 4 bites to see if this rule is going to be published. It has not been published yet. That means one of two things. It's going to show up this afternoon at 4:15 or some point later this week. Or for whatever reason, the departments have pulled the rule. They have decided to go a different direction. And as we talk about today, primarily the impact of the Texas Medical Association decisions on the federal IDR process, that may be in fact because of those decisions and moving forward with appeals of those decisions, the departments determined that it would not be appropriate this time to release the proposed rule. We don't know the answer to that.
The other option that could have caused them to pull it, in addition to the TMA decisions, is literally the fact that Congress is now stepping in.
Well, we won't go into a discussion of what's going on in the House.
That we won't go there, but there are letters being sent and just being asked what's going on here. And the other thing that Martie, I'm going to be totally off subject now, but even today we had news of a major provider filing bankruptcy. This happened to be an air ambulance provider. One of the reasons they gave for that was No Surprises Act. We've had it with a group of representing hospital-based physicians. So we wind up, are they getting to Congress as well and getting their concerns out there, and Congress getting more involved in terms of what's been going on since we passed this law?
Right, because I mean, this summer we've discussed at length the price transparency legislation that has been winding its way through Congress. It would not be surprising to see changes to the No Surprises Act being incorporated into that legislation as well. So that's why we have a proposed rule that we will discuss, which is the administrative fee and the cider fee rule. But we thought this was an excellent opportunity to walk through the No Surprises Act, particularly the surprise billing component of the legislation and the regulatory scheme. As it now stands, following extensive litigation, primarily led by the Texas Medical Association, we have 4 decisions from the federal court in Texas directly impacting the No Surprises Act. So we very cleverly refer to these decisions as TMA 1, 2, 3, 4. And in response to each of those decisions, the departments have taken action. And so we're going to try and provide you with as accurate a possible where we are today with the impact of that legislation on the process itself. If in fact this other proposed rule, the one concerning operations of the IDR, is published this week, we will of course prepare a summary for that and send that out to attendees, because we don't want you to be shortchanged by content for this webinar. So with that, let's start at the beginning. Have Kathy do a brief reminder of the basics of the No Surprises Act. So over to you, Mrs. Reep.
Yes. So what are we talking about here? If you will go back a little bit into the No Surprises Act, we're going back a couple of years, but essentially what we are looking at is a congressional action that really focused on the issue of surprise billing. So many complaints from patients saying, I did not know that I was going to get a bill, concerns about perhaps a physician being out of network. I didn't know I was going to have that additional doctor. I didn't know that he was out of network and now I have to pay his full bill, things like that. A lot of dialogue, a lot of discussion, and therefore the legislation came in that really was intended to put a stop to surprise billing. And as I said, because of some of the financial implications on certain provider types, we are seeing that perhaps it is, to some degree, doing what it was intended to do, whether right or wrong. But essentially, under the legislation, we had two real components to it. First of all, under the surprise billing, which is what we're going to focus on today, out-of-network facilities and providers are not allowed to charge patients more than their in-network cost-sharing amount for emergency services. So it was very clear in terms of even going through a good definition that actually I think helped a lot of providers, hospitals in particular, in defining emergency services to include the point of stabilization and who would determine stabilization and like that. But patients, if they went out of network for an emergency service, they could not be charged more than their in-network cost sharing. The rule also addresses out-of-network providers who furnish non-emergency services at in-network facilities. So on that first bullet, we said facilities and providers out of network. But second bullet says providers. So if you are an in-network facility and you have physicians who are out of network and the patient comes in for a non-emergent service, they too are limited to only charging the patient the in-network cost sharing amount. The process for defining cost sharing was outlined in the rule. And the big issue and what we're going to really focus on today is the establishment of a federal independent dispute resolution process to determine the out-of-network payment rate when there is not a state mandated, this is how we do it. So we've had a lot of discussion back and forth and argument over how we calculate that out-of-network rate. And so this is what, the focus in terms of the back and forth that we've had so much of over the last year and a half. Finally, the other part of the law itself addressed good faith estimates And as a reminder, it does require facilities and providers, that should be providers, not procedures, but providers to furnish notices and good faith estimates to self-pay patients in specified circumstances. You need to have your signage up there related to the ability to get a good faith estimate. You need to make sure that you are telling your patients that good faith estimates are available and actually providing those good faith estimates to patients upon scheduling. Marty?
So one of the challenges with the No Surprises Act is it was not the first law to address these issues. In fact, at the time the legislation was passed in December of 2020, 33 states already had some version of surprise billing protections applicable to state regulated plans. And the NSA did not purport to displace any of those state processes. In fact, it was intended as a gap filler to address those circumstances where state law was unable to resolve these types of disputes. So the premise of the NSA is if there is a state process that is applicable, use that state process to determine the patient's in-network cost sharing amount and or determine the out-of-network rate to be paid to the provider. But that is a multi-step analysis because first of all, you have to determine, does the state law apply to the plan at issue? Because states can only regulate fully funded plans. Self-funded plans are regulated under the federal ERISA statute and regulations, which displace state law regulation of fully self-funded plans. So that's the first question. Does the state law apply to the plan? Then the question is, does the state law apply to the facility or the provider? Is the facility or provider at issue licensed by the state? And then finally, the question of, is the state law applicable to the service? Because many of the state laws only apply to emergency services. And as Kathy just reminded you, the NSA applies to non-emergency services furnished by a provider in an in-network facility. So that is part of our challenge with the NSA, and part of the reason we've seen a backlog in the federal IDR process is because these eligibility determinations have to be made up front. And part of the eligibility for the federal IDR process is that there is no state process in place to determine what the out-of-network rate would be. And these are very challenging circumstances. And it also raises the question of, do you as the provider, can you in good faith determine that in fact the state law process applies? So how do you hedge your bets? That if you do have a dispute with a payer on an out-of-network charge, should you initiate the open negotiation period within that 30 days of receiving the initial notice of denial or payment from the provider? Because you need that open negotiation period to preserve your rights under the federal IDR process. So I think that's what we're advising providers generally, is that if you do have a dispute, there is question of whether the state law process applies to that particular circumstance, run a track concurrent to preserve your rights in both circumstances.
Marty, were we ever able to establish where the insurance is, where the provider is, where the patient is, and get an answer to that question?
I think we have an answer that and there's a FAQ that was published by the departments, which does address this question of the facility and provider, and they rely on licensure. So the reference is in their FAQ table, and they're determining whether state or federal law applies. Their question is the facility or provider that is bringing the claim or has provided the service, are they licensed in the state whose state process you're looking to resolve the matter? I don't know the issue on the plan because, as you know, a lot of plans will cross states. If I'm on, PYA has offices in 7 different states. And so is that plan applicable to a process that's available in Missouri, for example? But I don't think we have a clear answer to that.
Thank you.
So, yeah, that's one of the reasons we advise folks generally to go concurrent, if there's a process that applies. Where you know that, so another piece of this is, again, states can only regulate state-regulated plans, i.e. fully insured plans. So the federal process is going to apply if it is a self-funded plan at issue, i.e. the employer is actually bearing the risk and using a third-party administrator for the claims, except there are states, Georgia, Maine, Nevada, New Jersey, Virginia, and Washington, to be specific, where they have a process that allows self-funded plans to opt in. So in those cases, if the plan at issue has elected to opt into the state process, you would follow the state process as opposed to the federal process. Otherwise, state law is going to apply, again, and you see the list there, when you have a fully funded plan. And so this has been one of those very challenging areas to navigate in the rules, in practical application, and hopefully yes, we have some guidance from CMS, from the departments on this, but certainly we could be more clarity around this. We also have a lot of state legislatures who are reconsidering their Surprise Billing Act and determining whether it's appropriate to square up with federal law. No one's actually done it yet, but I know that certainly has been into consideration in some of these state legislatures that you see listed here. Kathy, back to you.
This is back and forth time. I just wanted to make sure that as we talk about background on this issue a little bit, that you are aware that there are a number of resources that are available to you that really get into the basics of the No Surprises Act. We have listed here a number of A, written documents, B, webinars that are available for you on demand, and finally a good faith estimate workflow that was developed within PYA. And that good faith estimate workflow, in case you haven't looked at it lately, has actually been updated to include the fact that the requirement for a good faith estimate to include co-provider information, that was delayed indefinitely. So that has been updated on this workflow in case you need to print off a new copy. For those of you who have stuck with us through all of these webinars, we want to thank you. Counseling is available, but if you do need to catch up, do a reminder, need something for your docs, they are all out there. That Complying with the No Surprises Act, a guide for physician practices, still out there. Nothing has really changed from those requirements, so wanted to make sure that you were aware that they were out there.
So for the next 40 minutes,
I feel like on the next slide I should go into song, but I won't.
Oh, thank you, Kathy. But we're going to spend the next 40 minutes talking about what has been impacted, what has been changing over the last year and a half to 20 months or so, which is the federal IDR process. And we thought back and forth about how to introduce this and decided a timeline probably best explains how these processes have been evolving. So we start back in December of 2020 when the No Surprises Act was signed into law. It was part of the Consolidated Appropriations Act of 2021. And what concerned all of us at that point in time was the effective date. That Congress said that the departments will be responsible for standing up these processes by January 1st of 2022, effectively 1 year from start to finish. And I think now we are paying the price for the rush to stand up this process. So we waited. So we knew the law was there, we read the statute, but we had to wait for implementing regulations and wait for implementing regulations. And we saw the first interim final rule published in mid-July of 2021. So now we're less than 5 months out from the implementation date. That interim final rule addressed surprise billing and focused in on the qualifying payment amount. Then about 2 months later, the departments published a proposed rule, which was intended to address enforcement of the No Surprises Act. That rule has never been finalized. It is still outstanding. There is commentary in the FAQs that the departments are still looking to publish that in final form. This is part of the reason you're not seeing a lot of separate enforcement activity around the NSA, because we don't have the civil money penalties or the corrective action plan, all that typical enforcement regulation provisions. Those aren't in place yet because that proposed rule hasn't been finalized. Then about a month later, so now we're in about 2 months, 2 months from implementation date, we get the second interim final rule. This one addresses the independent dispute resolution process, as well as the good faith estimate requirements. As I said, the effective date of the new law was January 1st of 2022. That's why we use the interim final rule process as opposed to the typical proposed rule process that the agencies use to roll out new regulations.
And
There
where
just
you can
wasn't
actually
time.
ask questions and get answers.
Exactly. So an interim final rule, if you're not familiar with it, is yes, we're going to make it final, but we're going to afford stakeholders an opportunity to comment, and we'll take those comments into consideration to make any subsequent changes to the regulation itself. It's allowed under the Administrative Procedures Act. It's certainly not the preferred way of rolling out regulations, but really the departments had no choice because of the short timeline for implementation.
But we've never seen a response to any of those interim finals.
Exactly. Well, part of that is because this legislation, but these regulations got mired in litigation very quickly.
Exactly.
So we had in 2021, the Texas Medical Association was the lead plaintiff in the first of the lawsuits, focused particularly on the qualifying payment amount for rebuttable presumption in the IDR process. So in that interim final rule in October of 21, the department said IDRs should determine the out-of-network payment rate by selecting the offer between the provider and the payer that is closest to the applicable qualifying payment amount. And so that was immediately challenged, and in fact, the court in Texas ruled that that rebuttable presumption was directly contrary to the statutory language. And so that sort of froze things up to figure out how that was going to move forward. Despite that confusion or that, I guess, lack of stability in the system, the federal IDR process actually opened on April 15th of 2022. And we began seeing through the processes of these determinations relating to out-of-network rates. Then in August of 2022, the departments published a final rule that replaced the QPA rebuttable presumption in the IDR process. So again, remember we had the interim final rule back in October of 2021. It's replaced, in effect, or portions of it are replaced by that final rule that shows up in late August of 2022, intended to address the decision in TMA 1. Then we have some good news in late December of 2022. Early December of 2022, the departments announced that they were going to delay indefinitely the co-provider requirements under the good faith estimates. They had first announced that they would delay it for 2022, but insisted that it would be in effect for 2023. And then at the beginning of December, they say, yeah, no, we're just going to indefinitely delay it. We understand that there are certain communication issues back and forth between co-providers, and we can't address that. So that's the good news, and that's really the reason the GFE requirements have remained stable throughout this period. An early Christmas present from the departments in December of 2022. On the 23rd, they announced that they would be increasing the IDR administrative fee from $50 to $350 for 2023. And this is the amount paid by parties to an IDR entity resolution that cover just the administrative costs. So this is not a non-refundable fee you pay at the beginning of the IDR process to simply maintain the IDR process. And the agency
and paid both by the provider and by the payer.
Exactly. So this is the department's coming back and saying, we had we were completely floored by the utilization of the IDR process. It's much more expensive than we had ever thought it was going to be. So we're going to have to increase, the IDR administrative fee 7 times over. So certainly that caught a lot of people off guard, because now to challenge effectively any claim the payment offered by the payer, it may in many cases cost more than the amount of the claim to do that, because you're from the beginning paying $350 that's non-refundable to just get to the IDR process.
And that was when we were also addressing what is a claim. Is it per CPT code or not?
Right, exactly. So that gets us to February of 2023 for the TMA2 decision, because the Texas Medical Association challenged the August 2022 final rule because it created a different process for determining what the out-of-network rate would be, but it still deferred to the QPA. It still said that in August of 2022, the department said, well, IDR entities, you should first look at the QPA, then consider other factors, and then tell us why those other factors counseled in favor of a rate other than the QPA. And again, the court said, yeah, no, that's not good enough. That's contrary to the legislation, the legislative language. And so the court vacated that final rule. So where it stands today, and we'll go into a little more detail on this, is that the IDRs are left with the statutory language and determining through consideration of the factors listed in the statute what the appropriate out-of-network rate should be. Then we fast forward to August of 2023, and we get the TMA4 decision. Yes, I know we're going out of order, but these are ordered by when the lawsuits were filed. TMA4 was a challenge to the increase in the administrative fee, as well as the regulatory standard for batching claims. We'll go into more detail on that as well. A couple weeks later, we get the TMA4 decision, which was a challenge. Yeah, 3. I said it wrong. Thank you. Okay, we go from 4 to 3. See why I got confused. But 3 decision vacated the provisions in the regulations concerning the calculation of the qualifying payment amount. So these were in the July 2021 interim final rule. Now we are challenging how the agencies interpreted the rules for calculating the qualifying payment amount. Remember, the QPA is calculated by the plan. And so this is a challenge to the directives given to the plans in calculating the QPA, again, on the basis that what the regulation said was, again, not consistent with the statute. That gets us to the September 26th proposed rule concerning the IDR administrative fee, as well as the range of fees that could be charged by a certified independent dispute resolution entity, or what we're now going to say refer to as the CIDRs. And so we have that proposed rule. As I mentioned previously, the comment period for that rule closes. And then finally, as we know, we still have that outstanding IDR operations proposed rule. So a lot's happened in a relatively short period of time. So let's start talking through where the IDR process stands following the litigation and the department's response to the litigation. And we're going to do this in the order of how a matter goes through resolution. So not in the order of the decisions, but instead the order of the process within the federal IDR process. So that starts with the QPA calculation. And again, the plan is responsible for providing the QPA to the provider at the time that it adjudicates the claim, because the provider has to have the QPA information to determine the appropriate amount to charge the patient. Because remember, the rule is you can't charge the patient more than the in-network cost sharing amount. Well, if the provider's out of network, how do you know what the in-network cost sharing amount is? And that is the purpose of the QPA. In the statute, the QPA is defined as the plan's median rate for the same service in 2019 in the same geographic area. And you find that median rate, and that's what we're going to assume is the out-of-network rate, the in-network cost sharing percentage will be based on that amount. What the court found in TMA 3 was that, and I love the language the judge used here, that the departments cannot ignore the plain requirements of the act merely because insurers may be inconvenienced. And they specifically addressed 4 matters relating to the calculation of the QPA. The first is including ghost rates. So remember, if it's the median rate charged by the plan has an incentive to maximize the number of rates included. That includes ghost rates. And a ghost rate it's included in the contract with a particular provider, but that provider never furnishes that service. So it's like including anesthesia rates in a primary care contract, because it's very unlikely that a primary care provider is going to administer anesthesia, other than maybe a local and doing a very small in-office procedure. Because that provider never furnishes the service, the provider has no incentive to negotiate the rate, and thus the plan has the opportunity to insert very low rates into those particular contracts. And thus that skews the QPA lower, meaning a lesser amount available for the provider to collect from the patient, because you're basing the patient's in-network rate based on a lower overall QPA. Also, the court found issue with the inclusion of rates for physicians not in the same or similar specialty, closely related to the ghost rate issue. The court overturned the exclusion of contingent payments. So you may have a fee schedule rate for a particular service, but that provider has an opportunity through either a risk-sharing arrangement or incentive-based bonuses to increase that fee schedule payment. The court said that should be included when calculating the QPA. And finally, and probably the most impactful, the court rejected the regulation that allowed the inclusion of rates from other plans that share the same third-party administrator. So you may have employer A has a self-funded plan, and they have their plan rates, but they share a TPA with employer B. And what the plans were doing was including in the QPA the rates negotiated for the plan sponsored by both employer A and employer B, simply because they shared the same TPA who had negotiated the agreements. So all of this, of course, throws up into the air all of the calculations of QPAs and how these should be appropriately handled by insurers to provide information back to the provider so that they can determine the patient's responsibility. The Department of Justice has announced that they do in fact intend to appeal these decisions. That was referenced both in the October 6th FAQs that were published, as well as news reports of their intention to appeal this decision. And the departments have no intention of issuing any guidance on this issue beyond what was included in the October 6th FAQs. Those FAQs direct payers to make a good faith, reasonable interpretation of the statutory language that remain in effect after the TMA 3 decision. So good luck, plans, do your best job, because we're not going to provide you any additional guidance. Just use the statutory language for calculation of the QPAs. And obviously, at this point in time, because TMA 3 remains in effect, those 4 specific points cannot be included in the calculation of the QPA. But they also add that they intend to exercise their enforcement discretion to permit plans to continue to rely on the July 21 interim final rule to calculate QPAs for services furnished before May 1st of next year. So effectively, even though the court has held the statute does not permit you to consider these factors in calculating the QPA, the departments have said, but we're not going to bring any enforcement action against you if you continue to consider the factors that were listed in the July 2021 interim final rule at least through May of next year. And we may, in fact, the department said, choose to exercise our enforcement discretion further and allow the continued use of these rules through November of next year. But we won't go beyond November of next year because we'll give you a full year to adapt your processes, payers, to calculate the QPA, apparently assuming that there's going to be an appeal and that there may be, in fact, further guidance, further changes to these rules. And we want to, again, not inconvenience the payers by having to recalculate the QPAs. So it's a pretty interesting, I'll say it out loud, end run around what the district court in Texas was attempting to do by squaring the regulatory language with the statutory language. Because yes, the directive in the FAQ to the payers is follow what the district court did, apply the statutory language, but then they also turn around and say, but we're not going to have any adverse enforcement action against you if you continue to consider the 2021 rules. So that's where things stand on the QPA today. Also, the other impact of TMA3 concerned when we count certain days starting. The initial payment and notice of denial. So remember, the provider files the claim for the out-of-network service. The payer then has to adjudicate that claim, and as part of that, include the QPA, but also inform the provider, whether they intend to pay a certain amount or simply deny the claim totally. And it's that action, how long does the payer have to make that determination? The statute says no later than 30 calendar days after the bill for such services is transmitted to the provider. So 30 days from the date that it's transmitted electronically from the provider to the payer, that's when they have to make a determination. The payer has to make a determination. The interim final rule, however, the July 21 interim final rule, says that 30-day deadline begins on the date that the planner issuer receives information necessary to adjudicate the claim, i.e. a clean claim is submitted. And TMA3, the court said, no, that clean claim is different from when the information is transmitted from the provider to the payer. And in fact, the appropriate rule is to follow what the statute says. So again, we have been waiting for adjudication of claims and provision of the QPA from the date that the payer deems they had a clean claim. And now we've accelerated that up with the decision in TMA3 to you start the 30-day clock from when the claim is transmitted, clean claim or not. So now we have the October 6 FAQs, which tell us, direct payers, that rather than simply denying these claims out of hand, we expect payers to communicate with the providers during that 30-day period and identify information that is missing that is necessary for actual adjudication of the claim. So now they want to accelerate this process when we have an out-of-network claim. As soon as the payer receives that, they should be identifying if the claim is incomplete and then communicating with the provider to secure that additional information as necessary. And then the further direction in the FAQ is that if the plan determines that it cannot make a decision on coverage within the 30-day time frame, the shortened 30-day time frame, then they should issue a notice of benefit denial without it suggesting that the service was determined to be non-covered. And so it may in effect be just moving the dispute down the road because remember, the trigger for the process is when the payer issues their decision of either no payment or no coverage, as well as the QMP. It's 30 days from that date, 30 business days from that date, that the provider has to initiate the open negotiation period. So we've accelerated that period of time now because of changing this initiation date and probably moved into the open negotiation period the resolution of whether the service is covered or not, as opposed to it just being a benefit denial. So
Marty?
yeah.
I was just going to say, for the providers who are listening to the call, whether you represent a hospital or a physician practice, it is so important for you then to make sure that the information that is on file with the payer as to who to contact and how to contact is constantly updated. It is very clear, because when we go into some information in a little bit about the payers who are saying that providers did not follow the process, you need to make sure that it is very clear who to contact, who is responsible for this, discussion, etc. I don't know if you go to the person who signed the contract, which could be the CFO, and can you reach the CFO? Is it someone in managed care? Is that person on vacation? How is this addressed and followed up on? Because you need to be really clear that this is the person to reach out to.
Exactly. Good practical advice. So again, as I said, the trigger to get to the federal IDR process is the completion of the open negotiation period. That's a prerequisite. And the trigger for the open negotiation period is when the provider receives from the payer its determination with regard to the out-of-network claim. So what we are seeing is a lot of drop stitches in this process, and providers effectively foreclosing the opportunity to go through the federal IDR process. So we are learning now that the significant backlog in the federal IDR process, and Kathy will go through in detail where that backlog is now, is due to these eligibility determinations. And part of eligibility determinations are tied to state versus federal process, and part are tied to whether the prerequisites for utilization of the federal IDR process have been appropriately followed. And that is primarily around the initiation of the open negotiation period, and then 4 days after the close of the open negotiation period, the initiation of the federal IDR process. So you have to fail the open negotiation period. You then have 4 business days to then submit through the portal the notice of IDR initiation, which is then delivered to the departments. So be very attentive to these timeframes, because you will foreclose your opportunities under the federal process if you miss these timeframes. However, the agencies have published a form that they want you to use if, because of extenuating circumstances, you require an extension of any of these deadlines. So if you should come up and realize, oops, we didn't get the open negotiation period started, we were on day 7 by the time we initiated the process, do appreciate that there is now a form to be used when you require an extension of any deadlines for extenuating purposes. You'll see in the footnote there the link to the Department of Labor website, which is where all these are housed, where you can find those forms. In addition to that form for extension of time due to extenuating circumstances, the departments have published several standard forms which they expect to be utilized through this process. The first being the notice of IDR initiation. That notice, the current version of it, is far more detailed than the original version of it. Because again, of these eligibility issues, the departments determined they want to front load the notice of initiation to include necessary information relevant to the determination of eligibility. So be sure you are utilizing that standardized notice, or again, you're going to get yourself caught in this loss of, this eligibility determination issue, which slows this process down significantly. There is also a standard form for notice of offer, notice of agreement of out-of-network rate between the parties prior to the cited decision being issued. Make sure you're utilizing those documents. Again, the detail here on the slide as to how the process goes back and forth. Just appreciate that a lot of these deadlines are being blown by the CIDers because they're not getting these eligibility determinations resolved. Part of that has been relieved by the more additional information required as part of the initiation process. Part of that has been relieved because the departments have actually hired staff to assist the CIDRs in resolving these matters. That's part of the reason the administrative fee went up, is because of additional staff to front end this with the CIDRs. So we are seeing some relief there. But still, this process has a ways to go in its maturity. Maybe the proposed rule, which we are promised, or maybe it's been pulled, will address some of these issues going forward. Also wanted to call your attention to the cooling off period. The initiating party cannot submit a subsequent notice of IDR involving the same party on the same claims. That is a 90 calendar day cooling off period before you can submit the claim again. So if you've had a particular issue with a particular provider, you may have to be navigating on the front end when you drop the claim to afford yourself additional time so that you don't get caught in the IDR process. Just another version of the federal IDR timeline for those of you who are visual, just to help you appreciate that this process is not speedy. And this is going to take nearly 200 days for the point at which you first file your claim, through which you receive payment of the approved out-of-network rate from the payer. And we have been hearing complaints that even after the IDRs issue opinions favorable to providers, there's been delay on the payer side in actually submitting the payment, the additional payment. There's also been complaints about when fees aren't paid appropriately by parties, how that also has derailed the federal IDR process, because effectively it shuts the process down if you don't pay the administrative fee at the top of the process. And so that's adding additional time delay as well. See, there may be some opportunities for Congress to fix some things here.
Definitely. Congress? No, never mind. Marty mentioned earlier that TMA4 was essentially, the opinion was issued in August of this year. And what we saw was this back and forth issue related to, can I file appeals, can I not, or disputes. So essentially when the decision was published on August 4th, right before that, we saw that there was a announcement that all of the federal IDR functions had been suspended temporarily. Almost well over a month later, they began taking non-batch disputes, so that's going to be single claim, single service disputes that had originally been submitted before that August 3rd cutoff date. So that if you had already submitted, then they were beginning to review those and process those disputes. Then on October 6th, we saw the departments reopen the federal IDR portal for initiation of new non-batched disputes. You have a footnote on the bottom of the slide that really addresses both by statute and by regulation what is meant by batched items and services. Unfortunately, I think that when we start looking at statutes saying related to the treatment of a similar condition versus regulation that says same or similar items or services, each must be billed under the same service code or comparable code under a different procedural code system, I think we are still open for a lot of confusion in terms
Kathy,
of what is batched.
Yeah, just to be clear, Kathy, it's the regulation that the district court in Texas vacated.
Right. And
right.
so,
Okay.
but I think we still have a lot of confusion. So we need to have a ruling on this in terms of what is meant by batched. Last week, they extended the deadline for the IDR entities to engage in the selection process on those claims that had been engaged in prior to August 3rd. And then we now have, as of November 3rd, that is the deadline to initiate the IDR process for those services where the 4-day open negotiation period ended between August 3rd and November 3rd. So is that confusing or not? Essentially, if you have something where the once they shut down in August the process, if you have not initiated the IDR process, you have until November 3rd to do so. We don't know what's going to happen with batched claims, and that's where I think we're going to be looking for a rule that is going to address what is meant by batched. I can honestly, and we're about to talk about the cider fees, we've had a lot of discussion from predominantly physicians who have had claims that they tried to appeal sent back because there were multiple, it was a single service, but multiple CPT HCPCS codes on the claim. And they were told each one of these needs to be submitted separately. Is that true? As a part of an emergency room service, all of these different things need to be submitted separately. And then for each dispute, you're going to pay a fee. You're not going to file the dispute because it's going to wind up being more than your reimbursement would have been to start with. So we need a lot of clarity on that one. On the next
mystery proposed rule, right? That's okay. Sorry.
Well, and I'm going to raise this something in a minute. In the proposed rule that came out a month ago, with comments due tomorrow, this is really addressing the administrative fee and the amount that the CIDRs can charge providers to make their determination. The issue that we're looking at is, first of all, when they established the rate, and we're now looking at a rate that, remember, we went from $50 to $350. Well, now they're proposing $150 that would stay in effect until they issue another rule that would increase, I assume, that $150. They are using data and the number of denials or disputes that were submitted between February and July of 2023. Well, are we looking at a lot of individual claims that because I had to separate each line item as a separate claim, or am I looking at an overall encounter with a patient? I think there's even a question in terms of that projected cost of $70 million to maintain the federal IDR process, and recognize again that it is a fee that is paid, that $150 is paid both by the payer and the provider. Also in this proposed rule was the fee ranges that would be paid not for opening the dispute with the IDR, but for the determination to be issued by the IDR entity. And this is going to range depending on whether it's a single determination, whether it's a group of claims that have been batched. And then again, we're looking at increases to these fees on an annual basis. I took a minute while Marty was talking because I just wanted to know how many people have commented on this rule where comments are due tomorrow. Through last night at 11:59, there have been 8 comments submitted. Interesting to note, there is one major payer. There are several state hospital associations. There is, well, I'll say it, HFMA. I know there are more comments that are pending. There are several physician groups or specialty societies that have commented. If you're thinking about commenting on this rule, again, you got until I believe it's 5 o'clock tomorrow Eastern time, but I urge you to go online and look at what others have said. You might want to read that one payer's comments. You might want to look at HFMA and some of the state associations. If you're a provider, you might want to start looking at it from a you don't even have to write a formal letter. You'll see that there's one in there that literally they just sat there under the comment and typed their comment. They didn't attach a letter. Take a look at that. You might want to actually provide your 2 cents into this process. 8 comments to date.
Just very briefly, I think we've mentioned this previously. We've walked through this based on the dispute process. The last is following TMA 2, which again went to this question of what's the deference to be given to the QPA in determining the out-of-network rate. The August 22 decision directed CIDRs, TMA 1 got rid of the presumption of the QPA is the correct out-of-network rate. That then gets you to the August 22 final rule. TMA 2 vacated that August 22 rule, that portion of the rule. The agencies have indicated that they are going to appeal TMA 2, and they have now directed CIDRs, in the absence of any applicable regulation directing you on how to determine out-of-network rate, you are left to apply the plain language of the statute and determine the out-of-network rate without giving any statutory circumstance any specific weight. So really, it is broad deference to the CIDRs to make these decisions, meaning the case you as a provider or a payer make to the CIDR is going to be more compelling. This gives you really the chance to make your case without being limited to specific factors that were in the regulations. Kathy?
Yes, looking at a date real quick here of the report. This is a report that was published April 27th, based upon a report that was published April 27th related to the IDR process, going for not quite a full year, but looking at the nature of the disputes and how the outcomes. There were 334,000, almost 335,000 initiated disputes. CMS says, or the agencies say, that this is 14 times greater than the number of disputes that were estimated. Again, we might be getting with that batching process in terms of what can be, has to be appealed separately. Of those 335,000, 123,000 of those were challenged in terms of the appropriateness. So 37% of the initiated disputes were challenged, I'm going to say probably by the payers as opposed to by the providers, but challenged. You can see that if you're going through this challenge process and whether it is appropriate, et cetera, you're going to delay the process because you're going to be doing this back and forth as to whether or not it is appropriate. Out of the 335,000, and then we have some that were knocked out related to eligibility, actually 107,000 disputes have actually been closed by the CIDRs. 39,000 or 37% again were found to be ineligible, and therefore out of that 106, we got almost 40,000 that were kicked out. So we're looking at about 60,000 claims here that were to be determined. 42,000 of those were closed, which is 49%. The initiating party prevailed in 71% of those payment determinations, and about 25,000 were closed for other reasons. It could be that the two parties came to an agreement and pulled out. But look at the number related to the 71% of the initiating parties prevailed. For those of you who've been hesitant to file a dispute, it looks to me like maybe right now the odds are in your favor.
And a lot of these were decided during the period of time when there was deference to the QPA.
Right.
So, very interesting stuff. As part of the NSA, Congress directed the agencies to publish an annual report on the impact of the NSA. That first report was published in July. You have the link there if you'd like to look at it. There's not a great deal in the substance here because, as I say, it's only a year in, how much can we determine? But they do talk about the framework on how they're going to evaluate going forward the impact the NSA is having on prices, spending, quality, access to care. And they also do an interesting review of state law studies. So states that have adopted some sort of surprise billing law, what's the research showing on the impact of those state laws? And what they have found consistently in that research is that there's been a decrease in both in-network and out-of-network prices. So it is having negative pressure on provider prices in those states that have adopted surprise billing laws.
It will be interesting on that bullet point related to access, if they will then take into consideration, air ambulance providers that are filing bankruptcy.
Right.
Yeah.
Kathy, we're at the top of the hour, so I'm just going to reference our attendees to the slides these are back to just two interesting topics we thought worth visiting from the August of 22 FAQs. One concerning plans that utilize reference-based pricing and how the NSA applies to those, as well as what do you do with plans that do not have any out-of-network coverage. But you can see on the slides there how the departments have advised. So we'll be back in 2 weeks talking about some other rules. Isn't that a pretty great description?
We hope, unless they decide not to publish those too.
That's not going to happen because we are all of the calendar year rules, so home health, fee schedule, outpatient, ESRD, all of them are sitting at OMB, have been there for nearly a month. We anticipate, based on prior practice, that it'll be Monday, Tuesday, Wednesday of next week when we'll start seeing these released. Kathy will take a good look at what's available, choose what's most appropriate to discuss, but it'll be either, most likely we'll talk about ops for the fee schedules, what our best bet is, but we will have sign-up material available for that soon. Again, as always, if you have questions, please insert them in the survey at the end. We'll do our best to get back with you. And again, if the proposed rule is published, we'll get a summary out to you of the key provisions soon. So thanks again for joining us.
Thank you.
Back to you, Trevor.
Thanks to our presenters, Martie and Kathy. Please remember to stay on the line once the webinar disconnects to complete a short survey. Later today, you will receive an email with their contact information and a recording of the webinar. Also, the slides and recordings for every episode of PYA's Healthcare Regulatory Roundup series are available on the Insights page of PYA's website, www.pyapc.com. While at our website, you may register for other PYA webinars and learn more about the full range of services offered by PYA. Please remember to stay on the line once the webinar disconnects to complete a short survey and post any questions you may have. On behalf of PYA, thank you for joining us and have a great rest of your day.